Can get started. Good morning, good afternoon, good evening from wherever you are in the world. Thank you for joining us today for this webinar on biodiversity risk for companies, legal developments. This webinar has a global focus with spotlights on Australia and South Africa. We are going to be looking today at the key takeaways from our biodiversity risk. So we will be hearing from Jenny Ramos, our biodiversity lawyer here at the CCLI, and Jeff Summer-Hayes, Senior Advisor at Pollination, Chair at Zurich, Non-Executive Director at Heartland Bank, Chair at Beyond Zero Emissions, and Steering Committee Member at the Climate Governance Initiative, which is part of the Australian Institute of Corporate Directors, as well as Paula Ann, who is a Senior Associate at Weber Wenzel, a law firm in South Africa. So today we will be hearing from Jenny regarding the key takeaways from the report, Biodiversity Risk, Legal Implications for Companies and Their Directors. So what is biodiversity risk and why is it relevant? What does biodiversity risk mean for companies specifically? And what should companies, directors, and advisors do about it? Our panelists, Jeff Summer-Hayes and Paula Ann Novotny, will be going into the developments specifically in Australia and South Africa. After that, we will open up an audience Q&A. So please feel free to share your questions in the Q&A function, and we will answer those questions live. So we're looking forward to your questions as we want this session to be as interactive as possible. Thank you very much. Over to you, Jenny.
Thanks, Julie. And hi, everyone. Good morning or good evening, depending on whereabouts you are in the world. So starting, obviously, what is biodiversity? I think probably most of you know what it is, but just to recap and make sure we do. Biodiversity is the variability among living organisms, from bacteria to large mammals, both terrestrial and aquatic. And it includes diversity within species, between species, and of ecosystems. Biodiversity loss and ecosystem collapse have been ranked by the World Economic Forum as the fourth most severe risk in the next 10 years, and also one of the fastest deteriorating risks globally over the next 10 years. Companies need to understand that biodiversity risk isn't just another buzzword, another fashionable tick box exercise, but it's a facet of existing risk categories and a hugely relevant factor in their long-term business viability and success. And we would say it's equally as important as climate risk, both in its own right, rather than as a subcategory of climate risk, but also hugely interconnected with climate risk. And the flip side of this risk is opportunity. There are big business opportunities in the transition to a nature-positive economy, which may not be discovered without considering in detail how each business interacts with biodiversity. So starting from the top left of this flow diagram and moving around, biodiversity underpins healthy ecosystems, which provide services to business and society known as ecosystem services. The functioning of the global economy and the actors within it depend on those ecosystem services. And we're talking about 44 trillion of US dollars of economic value here that is moderately or highly dependent on ecosystem services. And that's over half of global GDP. Yet business activities contribute to all of the 5 anthropogenic drivers of biodiversity loss, and those are change in land and sea use, direct exploitation of organisms, climate change, air, land and water pollution, and the invasion of alien species. Biodiversity loss is occurring at an accelerating rate, 100 to 1,000 times higher than that of the past million years. And there is international consensus on the financial and systemic materiality of biodiversity risk. So we've seen statements being issued by the UNPRI, the Task Force on Nature-Related Financial Disclosures, the World Economic Forum, and the OECD. Also, studies undertaken by banks in the Netherlands, Malaysia, France, and Brazil found high levels of exposure of their national financial sector to companies that were highly dependent on ecosystem services. And indeed, while I'll be referring to companies throughout this session, most of the concepts will apply to investors and financial institutions as a result of the risk arising from their portfolios. Questions that lawyers might pose to corporate clients might also be questions that financial clients may in turn want to ask of investee companies. This table, which you can also see in our report, shows what type of ecosystem services support which industries. And ecosystem services are divided into provisioning, regulating, and cultural services. And this illustrates why those services are so essential and how they directly support key industries and then indirectly support other industries as a result. On this slide, you can see how biodiversity impacts and dependencies can be transmitted to a wider number of industries and companies. Due to this indirect relationship, it might not seem evident at first that many companies have impacts and dependencies on biodiversity. When you look deeper through their supply chain, this is more apparent. We have detailed case studies in our report that illustrate how relevant this is to many companies. And value chains can encompass the activities of the company, its subsidiaries, its suppliers, indirectly and directly, and a full life cycle of a product or process, including upstream and downstream activities. And also a company's value chain can extend over multiple jurisdictions outside its corporate group. So what does this mean for companies individually? Having established that business depends on biodiversity, we need to think about the risk and opportunities to each company. This can be through loss of ecosystem services that affect their business, or where the company's impacts on biodiversity affect ecosystem services that other entities rely on, giving rise to potential reputational or legal risks or opportunities to the company. And consideration of risks and opportunities is a critical element in the performance of directors' duties. So you can see here in this diagram how those impacts and dependencies translate to risks and opportunities, which translate to things that directors need to be considering. Generally, directors' duties require acting with care and loyalty to their companies. So even without biodiversity-focused regulations and compliance frameworks, many existing national legal frameworks provide a reason to consider biodiversity risk within their corporate laws. So these directors' duties of care and loyalty are exercised in their core functions of strategy, oversight of risk management, attesting to disclosure and reports. And that's within, as I've said, the corporate governance laws. These duties are commonly, in different laws across the world, these duties are commonly assessed contextually within the context of legal, market and regulatory developments. And so the developments that I'm about to go on to talk about generally in terms of biodiversity enhance this by providing the context that informs the reasonable standard and indicates which risks are considered to be material. So starting with the context of biodiversity litigation risk, this is gradually materializing and it may follow the same trajectory and pace that we've seen with climate litigation. And this is not just against governments, but also against companies. Again, value chains feature heavily here. We've seen cases in the UK, the Netherlands and the Canada that indicate that courts will not initially strike out claims against parent companies for the conduct of their foreign subsidiaries. And although substantive judgments in these cases are pending, and some do deal with human rights, for example, not biodiversity, the same legal principles could allow for lawsuits against parent companies for the impacts of their subsidiaries in biodiversity-rich regions. There are also claims threatened related to disclosure and misrepresentation. And while no biodiversity-related cases have yet been filed alleging breaches of directors' duties, we've seen cases now filed against directors for mismanagement of climate risk. There's been a derivative action against Shell in the UK that hopefully you may have seen some news headlines about. It's been a pretty big thing. So we may see the same happening in terms of biodiversity in the future. Also, claims specifically focused on human rights may also encompass environmental impacts because the two are often linked. So just to give you a spotlight of one case as an example, this is a 2021 case against the French supermarket chain Casino, brought under the French corporate vigilance law. It alleged that Casino's due diligence failed to detail environmental and human rights harms associated with the supply of cattle from deforested areas via a supplier to Casino's Brazilian subsidiary. So you can see both the subsidiary and the supply chain effects coming in here. This type of value chain litigation has the potential to increase transparency on biodiversity impacts and dependencies in global supply chains. Moving on to the context of due diligence regulations. Around the world, various due diligence regulations are proposed or in force, and this is likely to cascade information requests through value chains. We have a quarterly update on value chain due diligence, which I think Julia is going to post in the chat. This is really important in that it can affect companies outside of the territories where such legislation is passed around the globe, not just companies incorporated in that jurisdiction or doing business in that jurisdiction. The reason why is because it will cascade information requests through value chains. And so companies who are subject to these rules will pass on these requests to companies outside that jurisdiction. It may also influence global best practice. And this extraterritorial effect of the laws around the world may increase transparency around previously hidden biodiversity impacts of companies. This in turn may raise standards of care and loyalty for directors of companies, both those who are affected by it and also generally, if it becomes part of business norms, it may extend eventually to directors of all companies. Turning to the regulatory implications of COP15, and this again is very important context. We have a COP15 jargon buster and a key takeaways blog, which we'll post the links to. But generally, if you're not aware, COP15 was the COP to the Convention on Biological Diversity, so different from the climate COP. In December 22, they finalised the Global Biodiversity Framework. Although this is a non-legally binding framework in terms of how it relates to companies, and also it's not binding on states, it's a tool and a political commitment, and countries have agreed to integrate it through their national policies and regulations. Some people have suggested it's a Paris moment for nature, suggesting that it holds similar significance for biodiversity as the Paris Agreement did for climate. And that remains to be seen. Hopefully it will be. It has 4 long-term goals to 2050 that broadly cover conservation, restoration, use and valuing of nature, and sharing its benefits and financing. It also has 23 targets for 2030, and this is what states have committed to implement through their laws. States also have to make national biodiversity strategies and action plans, and which are seen as being the teeth of the CBD because they promote responsibility and transparency. States have to update those national plans to align with GBF targets and report and review on progress. And this gradual ratcheting up of ambitions over time mimics the mechanism of the Paris Agreement. But why is this important for companies? What are the implications? So the headline 30 by 30 target will result in the expansion of protected areas. This may affect businesses in extractive sectors such as agriculture, logging, fisheries, mining, and their dependent sectors such as cosmetics, fashion, and electronics. Target 19's mobilisation of finance could create opportunities for new business. But most relevant to business is Target 15. And this is quite groundbreaking in that it covers biodiversity-related disclosures and explicitly relates to the role of business. So for a treaty to actually explicitly mention business is fairly new. Not only will states need to encourage all businesses to monitor, assess, and disclose biodiversity risks, dependencies, and impacts, but it also specifically includes countries making this disclosure and assessment a requirement for all large and transnational companies and financial institutions, including through value chains and portfolios. It may also impact what law perceives as a reasonable level of knowledge for a prudent director and increase biodiversity liability risk. But we don't know yet when states are going to implement this, and so everybody's waiting to see what will happen as a result of the commitments they made in December. Ahead of any legislation coming in to implement COP15, we also have disclosure frameworks coming in. And so you may have heard of the Task Force on Nature-related Financial Disclosures or the International Sustainability Standards Board. So this might mean that these are voluntary standards, but it may be that they are imposed by investors, insurers, or contractual partners, even ahead of being implemented into laws. So the TNFD is working on a global set of standards for companies to disclose nature-related risks and opportunities. And at COP15, the ISSB announced that it would incorporate biodiversity into its draft reporting framework. In addition to the non-financial statements, there's also a potential in the future for biodiversity risk to be required as a disclosure in financial statements where it's considered material enough, because the IASB has indicated that companies should disclose material emerging environmental risks. So as you can see, it all hinges on the materiality, which we're going to come on to shortly. So this slide shows the current version of the TNFD's recommended disclosures from beta version 3. Beta version 4 is due out at the end of this month, maybe even next week, I think, with final recommendations due in September this year. Those of you who are familiar with the TCFD's climate disclosure recommendations will see that it's quite similar and it's modelled on them, but the highlighted areas here in yellow show key differences. There are additional disclosure requirements on the company's interactions with ecosystems, how they cover the supply chain, and how the company has engaged stakeholders, including rights holders. Understanding the dependencies and impacts of other actors on nature is critical to understanding nature-related risks and opportunities. And stakeholder engagement is therefore a critical cross-cutting element in the TNFD framework. The TNFD recognises the value of local and Indigenous knowledge as highly effective for the protection of ecosystems. And it's looking like the final framework, or even beta version 4, might include some human rights due diligence and the principles of free, prior and informed consent in relation to nature-related disclosures. One critical difference in beta version 3 compared to the TCFD is that throughout, as you can see from the highlighting here, not only does it talk about risks and opportunities, but it also requires disclosure of dependencies and impacts. This is really significant in that it widens the scope of materiality. So with materiality being a relevance threshold for risk disclosures, it's historically focused on the one-way relationship between the company and the environment, known as single materiality. The TNFD has expanded this to a double materiality approach, focused on a two-way relationship between the company and biodiversity. It requires disclosure of dependencies and impacts of the company, as well as risks and opportunities. And it seems to be that this is regardless of whether those dependencies and impacts actually create any risks and opportunities for the company. These developments in materiality for disclosure purposes may affect the standard expected in governing the dependencies, impacts, risks and opportunities that are disclosed by the company. Furthermore, as such disclosure becomes best practice, it might also affect general best practice standards and raise the bar of what is expected in the governance of non-disclosing companies in similar regions and sectors, and maybe eventually around the world. So just the final element of that context is the investor attention and financial mechanisms. So investor frameworks indicate a growing appetite by the world's biggest investors for managing biodiversity risk, which signals that investors deem biodiversity issues to be material. We're also seeing developments in natural assets, impact investing, and natural capital accounting that are bringing biodiversity into the financial mainstream, recognising its intrinsic value. And this investor attention to biodiversity may therefore affect duties of disclosing companies. In addition to biodiversity risk disclosure requirements, we may also see investors requesting companies to set science-based targets for nature under the new framework that's being brought out by the SBTN. So now I've set out all the context, what should companies, directors and advisors actually do about this? So this is just a summary in these boxes here of everything we've discussed today: the biodiversity regulatory risk, compliance risk, litigation risk, and also how biodiversity fits into corporate governance. These are questions that are going to be asked over time and possibly by clients. And then here's a list of questions that you can ask for clients and colleagues. This list is available in our report with further details and references. Just to stress here that avoidance of liability is a minimum bar. So even without the threat of litigation, directors will want to avoid or mitigate reputational issues by aiming for prudent governance informed by best practice. So for companies and financial institutions alike, a prudent approach may entail building an internal capacity to understand the company's interface with biodiversity, and preparing for biodiversity-related disclosures as part of the transition to a nature-positive economy. You can find case studies in our report with footnotes to various annual reports of companies and research studies that give practical examples of multinationals that are already assessing biodiversity risk and their biodiversity footprint and implementing biodiversity strategies and targets. So for companies that are just starting out on this, that could provide them with inspiration. And hopefully you might find these questions useful to consider for your colleagues and clients. So I will pass back over to Julie to introduce the panelists.
Thanks so much, Jenny. So today you'll hear from Jeff Summerhayes, who is a senior advisor at climate investment and advisory firm Pollination, chair at Zurich and non-executive director at Heartland Bank. He is also chair of Beyond Zero Emissions and former Australian Prudential Regulation Authority, APRA, board member. Jeff was a member of the executive committee of the global standard setting body for insurance, the International Association of Insurance Supervisors, and chaired the UN Environment Programme Sustainable Insurance Forum, and represented the International Association of Insurance Supervisors and the Sustainable Insurance Forum at the Central Banks and Supervisors Network for Greening the Financial System, the NGFS. One of his most influential roles was as chair of the Council of Financial Regulators Working Group on Climate Change. Jeff is a former financial services CEO and director. He is renowned for his leadership in raising awareness of climate change financial risk in Australia and globally. He was described in the Australian Financial Review as the driving force behind APRA's push for climate risk standards. As for Paula Ann, she has experience in conducting environmental due diligence, investigations, and legal compliance audits, as well as contractual drafting and drafting legal opinions on a range of procedural, substantive, and regulatory queries. In addition, she has assisted clients engaged in environmental permitting applications, prosecutions, and appeal proceedings. She also compiles informative pieces and client alerts on legislative amendments and regulatory updates in environmental regimes, and has drafted textbook chapters and contributed environmental knowledge to various institutional platforms. Her experience extends to advising clients on ESG-related impacts, risks, and opportunities, such as opining on dedicated environmental and climate change-related laws, advising in support of project development and strategic M&A activity, establishing governance systems and procedures, and regulatory mapping. In 2022, she spent 6 months at Linklaters LLP in London on a secondment to their ESG team. So with these fabulous bios, I would like to pass over to Jeff. Jeff, over to you. Thank you.
Well, thanks, Julie, and thanks for that very generous and fulsome introduction. You're very kind, and it's great to be with all of you and the CCLI. And Jenny, well done on a great overview of nature and biodiversity risk. I'm sure the participants find that very useful, and hopefully I can give you some practical applications of that, of what we are seeing. And as mentioned by Julie in her generous introduction, I work with climate advisory and investment firm Pollination, and we are now a global firm working across the continents, have a big presence in the UK, Australia, the US, and the Asian markets. And we're working in food and fibre, we're working in the built environment, we're working in energy and industry, and also financial services. And I guess what we're seeing is the real awakening of this issue around nature. And I think the direction of travel on nature and biodiversity is very clear. And perhaps the way to think about it is that we've unfortunately spent about 2 decades getting to grips with climate and climate risk. And that has really gained momentum in the last, I guess, 5 to 6 years, particularly in the financial services sector. But there is an expectation that nature and biodiversity risk will follow the climate playbook, but on fast forward. So this is why sessions like this are incredibly important, because the direction of travel is clear, and it is likely to play out so much quicker than the implications for directors, companies, and broader stakeholders than in fact was the case with climate. And certainly at Pollination, that's what we are seeing with our clients and their various stakeholders. So Julie and Jenny, and before we go to Paul Rand, I thought I would talk about stakeholders and give you some context in Australia, but also, you know, I'm sure that is applicable in other jurisdictions as well. So who are the stakeholders? Well, I'm going to talk to 5 groups: customers, employees, regulators, and central banks. We do a lot of work in financial services, and then also governments and investors, and just give you a lens on each of those. And each of those stakeholders is expecting more from firms than has been in the past. Certainly that is the case with climate, and increasingly we're seeing nature and biodiversity play into that. So let me give you some examples, starting with customers. So we know that customers want their firms that they're dealing with to be responsible. We know we want them to be showing concern for our climate and the environment. And while they're not talking about biodiversity as a category, actually, when you dig into the issues, that's exactly what they're saying. They're just not using that label. So they're expecting firms to be conscious of their impact on the environment, on nature, and by inference through to biodiversity. The Responsible Investment Association here in Australia recently conducted a survey, and they found that 74% of Australians consider environmental and social themes when they're investing. And I guess that's an investor's lens, but we're seeing similar results coming through from customer and customer preferences. So you know, that is, of course, of economic interest to firms. With employees, similarly, we're seeing employees becoming increasingly conscious of their employees' action on climate change. And when you dig deeper into that, that's a factor as it relates to nature as well. And so from an employment brand point of view, from a company attracting talent, you know, which is very difficult globally at the moment, with low levels of unemployment and mobility of talent with remote working. Actually, what a company is doing on their broader purpose and their broader impact is becoming fundamental to attracting talent. So we are seeing that as play out as a factor in terms of mobile talent making choices of where they work. Moving across to regulators, central banks, and in that category, of which I have some familiarity with, we've seen a lot of action in the climate area. We are now seeing, from a government point of view here in Australia, the Australian government is consulting on mandatory disclosure as it relates to climate across all major large firms. That is already the recommended position in financial services. With the financial services regulators, APRA and ASIC have given very firm guidance on what firms should be disclosing in line with TCFD. Same is the case with listed companies of the Australian Stock Exchange. And also we are starting to see action by the Australian Consumer and Competition Authority on firms that are making representations around climate-related issues that they're unable to substantiate. So what's emerging, again, following that playbook on nature, is that the Australian government has been one of the major funders of the Task Force on Nature-related Financial Disclosures. In fact, the task force is headed by an Australian, and the Australian government is a big funder of that. So I guess there is intent there. The Australian Conservation Foundation has already, in a recent piece of research, found that directors are already likely liable for nature risk where it is found to be material, foreseeable and actionable now, in an opinion that they gave. We know about ISSB and disclosure requirements, and that's been weaved into the conversation on nature and biodiversity as well. And Jenny referenced the Network for Greening the Financial System, which is the nearly 100 central banks and bank supervisors globally, which is actively engaged on nature, having done a lot of work in recent years on climate, and that will have a cascading impact down to regulated firms. So while in many jurisdictions that is currently not a standard or a requirement, it is very clear, again, the direction of travel, and it's just an issue of not whether, but just when that becomes sort of built into mandatory requirements. So we are starting to see, again, back to governments. You reference Montreal and COP15. Australia was a signatory to COP15. So the federal government is committed here in Australia to ensuring that 30% of our land, water and marine ecosystems are conserved and managed by 2030. There's a Leaders Pledge for Nature, where Australia has joined other nations committing to reverse biodiversity loss by 2030. Threatened species, we have not done well on that score here in Australia, and the government again has a 10-year plan to improve the trajectory of 110 threatened species and 20 places of significance that are under threat. There has been a recent review of the government's environmental planning and Biodiversity and Conservation Act, and there was a number of recommendations about making that act stronger with some more teeth, and as a result of that, there has been a new Environmental Protection Agency proposed that has come out of that. And the federal government is currently consulting on a nature repair market or a biodiversity credit market to go alongside the carbon markets. And in fact, that is at a federal level. Some of the state governments, where I am here in Sydney and New South Wales, the state government of New South Wales already has such a system operating or in pilot. So let's look at investors, which is my last category before handing across. We are seeing the investors, both of firms and themselves, be active in terms of where they're investing and asking those questions of the companies they're investing in, but also being conscious of their impact themselves as funds. ANZ, one of the large banks here in the Australian marketplace, has made statements in their disclosures how they are now expecting their large corporate clients to respect international and accepted protocols as it relates to nature and biodiversity in their activities, and they'll consider those things when they're making decisions around lending. We know of firms like BlackRock, who have been very active in the climate space, Aviva likewise, HSBC. And I just finished by mentioning that on nature, which again is an area that Pollination as a firm, both from an investment and advisory point of view, has been active in, we have a joint venture with HSBC with a firm called Climate Asset Management. And we have just closed a mandate for 2 funds with nearly $600 million committed to those 2 funds to invest in nature. And I guess this is the flip side of the risk dimension, that there is a huge opportunity when we start to think about nature as an asset class and an ability to actually mobilize the financial system for good and for repair, and actually recognizing nature, as Desgupta had described, as an economic benefit and economic good, leads to the opportunities to invest in nature. And we were very pleased to close those funds with $600 million committed investment along Pollination with our joint venture partner, HSBC. So with those comments, Julie, thank you for the opportunity, and you as well, Jenny. I look forward to the Q&A sessions shortly. Thank you.
Thank you so much, Jeff. That was really interesting. We learned a lot about the Australian context. So with this, I would like to pass over to Paula Ann, who will tell us about the South African context. Thank you so much. Paula Ann, we can't hear you very well. Can you try maybe with your headphones?
Yes.
Sorry, everyone. Paula Ann's been having some technical difficulties this morning. No. I wonder whether we can maybe, Paula Ann, would you like a bit of time to try and sort it out, and we can jump to Q&A whilst you're doing that? Is that okay? Thank you. Sorry. Jeff, I wonder whether anyone's got any questions for you. I hope you don't mind doing the Q&A a bit sooner. Does anyone, I can see it's empty at the moment because people haven't been ready for Q&A, but does anyone have any questions whilst we're waiting for the tech situation to get sorted?
I think I'm back on if everyone
Are you back on? Oh, brilliant. We can hear you. Fantastic.
Great. Thank you. Sorry, I don't know why we have these tech challenges still in this day and age, but thanks very much for the platform to speak about the South African position. Really, we have a very fast-moving regulatory and policy landscape when it comes to biodiversity, which has now become critically important, and its importance has been understated for so long. And so recent worldly and market developments have been very key in pushing this agenda forward. So in South Africa, for us, it really starts with our constitutional imperative. So our constitution is the supreme law of the land, and we have a dedicated right to a healthy environment. And that constitutional right must filter through all governmental and corporate activities and means and measures to secure. And that constitutional right is very well drafted within the language of securing biodiversity specifically. So to pull out a few terms, our government has to take reasonable legislative and other measures to prevent pollution and ecological degradation, promote conservation specifically, and secure ecologically sustainable development within the context of socioeconomic development. So that supreme law of the land has already been rooted in biodiversity specific language since 1996. And in order to progress or achieve that constitutional imperative, we actually have dedicated biodiversity legislation in the country. So since 2004, we've had a Biodiversity Act, which governs how any form of economic or socioeconomic development must take place within the context of biodiversity conservation and sustainable development. And under that lens, we also have very broad and progressive environmental legislation generally. So to speak to all the concepts that Jenny has very helpfully shed light on today, the corporate director duties and corporate responsibilities in our country also framed within the context of environmental conservation. And so those duties are codified in environmental legislation, and they are dedicated environmental duties of care that are imposed on corporates and directors alike. And we have a very extensive and complicated legal framework that regulates that. There are also changes coming, given all the market developments and the increasing stakeholder expectations that Jeff has spoken to. And so last year, our government published a new policy paper that acknowledges the way the market is moving and the fact that almost half of our country's biodiversity that was assessed in undertaking this new policy framework is under threat of severe degradation and loss. And so our government is actually planning an overhaul of this Biodiversity Act and related environmental legislation, and we will see various amendments coming over the next few years. One of these has already actually been published, but is not yet law, and that is the recognition of animal well-being within the context of ecosystem services. So this new policy position is what's going to frame the way biodiversity legislation changes in our country going forward. Outside of that, we also have very interesting developments from a corporate business and tax perspective. South Africa is the first country in the world to have published or included in their tax legislation a biodiversity tax incentive. And what this means is that where you buy or control land for biodiversity and conservation purposes, you can now claim a rebate on that, on your conservation measures and costs year on year against the value of the property. And how that works is a very detailed system and methodology in discussion with our tax authorities as well as our environmental authorities. But we've seen a big uptake in this over the years, and that's very much helped push the agenda, not from only a risk and liability perspective for corporates, but as well as that opportunity side of things. And finally, the constitutional imperative of our country very much pushes an acknowledgement of human rights broadly and generally. And Jenny spoke to briefly, there is also increasing litigation in the space. It started with climate change, and the investor push on ESG has pushed climate change and now biodiversity loss into the frame of corporate activity very clearly. And so what we're starting to see is litigation on this front, particularly in the sense of corporates making commitments to respect human rights, within the framework of the United Nations Guiding Principles, so those UNGPs. That's also a voluntary document, much like the other conventions and frameworks that Jenny and Jeff mentioned today. But when corporates make a public commitment to respect these or to implement them in their own practices, you are elevated to a higher standard and a higher duty of care. And so we're seeing more and more corporates being taken to task by the various stakeholders that Jeff mentioned, particularly NGOs and shareholder activists in the corporate sense, holding companies to account for not complying with their commitments to human rights. And interestingly, it was only last year that the UN adopted a resolution which actually recognizes the right to a healthy and clean environment as a human right in and of itself. It's always the right to biodiversity and a healthy environment has always been framed in the context of human rights more broadly and all the other international ones. And now we have a dedicated environmental human rights. And that UN resolution acknowledges and recognizes specifically that biodiversity loss impacts the enjoyment of all other human rights. And so this plays into a lot of our engagements at a South Africa level, if you think of us as a developing country, and that the right to free and prior informed consent, Indigenous communities, their Indigenous peoples and their human rights, those are intrinsically linked to biodiversity, natural resources, heritage and culture. And so our policy developments and how our legislation is going to change over time is going to be within that broader framework and understanding. So those are just some of the interesting things to look out for in our market.
Thank you so much. And I'm really glad that you managed to get your sound working so that we could hear all that. It's really fascinating, especially just hearing from the two different jurisdictions about the similarities and differences there. So I can't see any questions. Does anyone from the audience want to pose a question? Whilst people are thinking of questions, Julia, I don't know whether you want to do the poll. Have you got it ready? We've got an audience poll for you. So you should hopefully see that appear on your screen. Do your colleagues or clients get questions regarding biodiversity risk? So yeah, we're seeing lots of yeses there. Interestingly, we did this the other day with the audience from the UK and Canada, and I think it was it was over 58%, I think, that were saying yes, they were getting those questions, and even higher today. We've got a question. To both panelists, how do you see any likelihood of friction with legitimate interests in the agriculture sector around such matters as land use and animal welfare? I don't know who wants to take that first.
I'm happy to have a go. I mean, I think we need to be careful of not demonising agriculture. There is, you know, there's 7.5 billion people on the planet, and we need to feed them. And it's been you know, it's been a miracle the way we've been able to do that. Unfortunately, we've done that over more recent decades with not a great as much consideration to the damage that it might be doing to the natural environment. And so governments have told landowners to clear land, and in fact here in Australia they were paid to clear land because that was going to make the country more productive, and now you know, people are being prevented from clearing land, and so and in fact prosecuted for doing so. So you know, I think the pastoralists and the farmers have been on a bit of you've been told to do one thing one generation, then another thing another generation, and so they're in a difficult position. And so there are sometimes very simplistic solutions to this. What I would say, and we've seen this again with some clients we're working with at Pollination, is the regenerative agriculture movement, which started at something on the margin, is now really mainstreaming. And so people that have practices that have more consideration for soil health, for biodiversity on their properties, are getting beneficial treatment from banks, insurers, and indeed some investors, and increasingly finding opportunities to have other sources of income, initially carbon credits, and here in New South Wales there's been some, as I mentioned, some trials on biodiversity credits. We have a very large client at Pollination who is a beef producer, and they have just pivoted their whole operation from being a producer of beef to being a custodian of the soil, and the whole mantra around the organisation has been soil health. And if they focus on soil health, they'll grow more grass, they'll they'll fatten more beef in a more sustainable way, and they'll drive a better top line for their organisation. So I actually think agriculture is a really promising and a very exciting area. It pasture sequesters carbon, often more efficiently than trees and other natural vegetation can do. And so, there is a lot of opportunity in the agricultural sector for it to be as much a part of the solution as it is sometimes criticised as being part of the problem. And I think that extends to animals as well, which there is a tendency to demonise animals with new feed supplements. Seaweed in feed supplements for cattle, for example, reduces methane output significantly. So, it's a very exciting area, and there's a lot of innovation. And as I said, we should think about it increasingly as part of the solution.
From our perspective, I would just raise the concept of sustainable development. The idea has been around for decades, if not longer, and that concept solidifies these exact kinds of tensions, and that you have to balance out your impacts to the environment within the context of seeking social and economic development. And for us, because sustainable development is enshrined in that constitutional right to a healthy environment and is codified in the environmental legislation, it's an imperative that if you are undertaking agricultural or other development activities, that you have to acknowledge these tensions and adequately secure, conserve, and protect the environment and the impacts that you're occasioning through those activities. Agriculture for us has also been identified as one of the key at-risk value chains and sectors from a climate change and biodiversity loss perspective. And so government is actually revisiting the agriculture sector in the coming months and years within the context of the just transition to a lower carbon economy, to understand those tensions exactly, but more specifically for the environmental context of agriculture. So for our perspective, mining, tourism, and agriculture are the key at-risk value chains from that perspective, which are going to require more inputs and policy positions from the government. And the question around animal well-being is one of those examples where we have now our new draft policy position to overhaul our biodiversity specific legislation in the country to deal with these tensions and increasing impacts and the increasing level and stage at which biodiversity loss is occurring. And that most recent legislative development did see now that we have animal well-being drafted into our Biodiversity Act as an obligation imposed on developmental activities.
Brilliant, thank you. Next question. What is the general appetite from companies when entering these discussions around reducing impact on biodiversity? There is a challenge on putting numbers on damage to public goods and externalities, so regulations to frame this is hard. I like the idea of tax incentives in place in South Africa to encourage companies to explore their impact in their own context. I think that's to either of you. It's from somebody in South Africa though, so I don't know whether Paul Ann, you want to take that first. Oh no, Paul Ann, you're on mute.
Again. Okay, yeah. I think the appetite has significantly increased since the uptick in ESG, and everyone must be well aware with the ESG boom word and keyword that's taken over the market since now. But the financial services sector has really driven that, and because it's the concept of money talks and where money flows, the decisions follow, there has been a much wider understanding of the risks associated with these, given all the stakeholders that are now involved. And this move from the traditional shareholder capitalism model to the stakeholder capitalism model, where we now have varying stakeholders within our internal and external environments that have expectations, want to understand what our business risks are, what the opportunities are, what the impacts are, and you have to report back to all of them. So all the different frameworks that Jenny already mentioned and the different market developments, especially from an investor perspective that Jeff mentioned, have really changed the way we talk about these things. And especially in our market, we've seen that because there are so many more risks, because we're one of the most biologically diverse countries in the world, but because there's so much opportunity as well coming from these engagements and discussions with investors. So people are much more aware now of the risks, and given the very vast increase in litigation, that risk awareness is all the more there.
Thank you.
Yeah, I agree with all of that. I do think governments have, and I think this is part of the question, I agree with Paul Rand's comments. I do think governments have a really important role to play here. We're dealing with nature as a new asset class, as a new notion in terms of its economic value, and so we have to encourage and accelerate development of that as a market, and governments do have a role, I think, to help stimulate that. It's always dangerous, governments trying to back winners, but here in Australia we have the highest installed solar base domestically anywhere in the world. We have a great climate for that, but nationally it's sort of in about 20% of houses. In some states it's in the high 20% of houses have installed solar, and that's been the case for some time, and that in part is because of government incentives that drove that, and thank God that did happen, because that was at least one of the more forward-looking transition initiatives that were put in place. And I think we could think about similar parallels with developing biodiversity credits, biodiversity markets, developing natural capital as an asset class. Whenever something's new, investors are tentative. If governments can help facilitate that, take a first loss layer or a first layer of investment, and develop these markets and get them established as co-investors, I think that would be very helpful. And it's incredible the amount of global capital at the moment that's moving around, and the opportunities in the US with the so-called Inflation Reduction Act, which we hear of global investors saying, well, we're looking at Australia, but actually the incentives are better to go and invest in America at the moment than they are here for global capital. So you do have to create an environment, a policy environment that is aligned to where you want to take things, and that does involve often incentives or tax deductions, etc., which I think have a very legitimate place to accelerate outcomes.
Thank you. We've got one more, and it's addressed to Paul Rand, but I think it could be applicable in Australia as well. So within the South African context, corporate South Africa has focused almost exclusively on climate change and are grappling with TCFD requirements. How do you see the uptake of TNFD, considering the complexity around targets, metrics, and indicators, and how tangible is this for company directors?
It's a very good question. I think we are in one of the more immature markets when it comes to understanding TCFD or broader sustainability reporting, and it has been a focus to support the climate change imperative for now, given our UNFCCC Paris Agreement obligations. That said, given the legislative focus, and we have resource-specific legislation, so we regulate air quality, we regulate biodiversity, we regulate water, we regulate waste, and we regulate them in buckets. And now that we're seeing how the market in the global world is changing from a regulatory and policy perspective on how these interplays happen from a sustainable development perspective, we now have to grapple ourselves with that stuff. And given that investors are pushing more requirements, more understanding on all of the corporates in the space, we're also seeing that. So the short answer is that it will take a bit longer for us, but the more hopeful answer is that given that government is already looking at this from a policy perspective, and given the importance of driving policy, as Jeff just mentioned, it's that when these legislative amendments come through our new draft policy position that was published last year, then that awareness will have to increase. That said, the market still here is focused on legal compliance, and understanding frameworks like TCFD and TNFD has become less of an importance factor for our corporate clients, given that they focus first on legal compliance and the consequences that attach not to that. But within the understanding of work that Jenny and team do, and understanding how the role of directors, how duties of care have evolved, to understand all of these converging risks from an external environment perspective, corporates do now have to take it seriously in trying to find the capacity and the skill sets, either internally or externally, to engage with these frameworks and understand how their obligations and duties of care are evolving.
Thank you. Jeff, I've got another one for you actually, which kind of links a little bit to the metrics part of that question. So it's, how do directors or companies navigate governing these risks and seeking to make disclosures in the face of the current limitations around data, science, methodologies, standards and guidance, etc.? Especially in Australia, where there are strict liability regimes for misleading disclosures, regardless of best intentions.
Yeah, so yeah, there's a lot of debate currently at the moment about safe harbour provisions as it relates to climate-related disclosures, which the government is consulting on at the moment. Yeah, it's argued, there are a range of views on this, it's argued that directors already have that liability irrespective of new requirements coming in, and under the Corps Act, directors have as viewers would know, have a liability for care and diligence there, and if they need to assess whether the risk is material, foreseeable and actionable now to their company. So ASIC has said previously, the corporate regulator here on such matters, that considered disclosure is better than no disclosure, and that provided the disclosure doesn't have to be in of itself right ultimately, but the disclosure, when it is made, has to be considered on the best available information and made with care and diligence and properly informed. I should add, I'm not a lawyer, so I'm not one to take that as a definitive position, but that is my understanding of how the law works, and I'm happy to stand to be corrected on that. But provided directors have taken appropriate advice, have made due inquiry, and have made that disclosure in good faith based on the best available, if subsequently that turns out not to be entirely as they had thought, that doesn't necessarily make them liable, but I'm happy to be corrected on that. What we don't want to do in these disclosure regimes is that we don't want to push directors and companies into a risk-adverse position where they are not disclosing. I think this is a very live policy issue at the moment. We have to encourage the good actors to come forth so that markets can be properly informed, and we have to find a way to seek out the bad actors and seek redress where that's appropriate. But I think it would be a shame globally if a lot of these new requirements push people into a risk-adverse, pulling down the shutters environment, which is perhaps where that question was alluding to.
Thank you, Jeff. And I've just posted in the chat, there was a recent legal opinion on safe harbour matter in Australia. So I've just posted the link to that in the chat because I think that backs up what you were saying. I think we've run out of time. It's gone very fast. Thank you so much for all your great questions. And thank you so much to Jeff and Paula Ann for joining us and giving us their insights and practical examples. It's been, I've learned so much. It's been really interesting. Thank you.
Thanks for having us.
Thank you.
Thank you so much. Have a
Please
good day.
keep in touch with us and let us know your feedback. Let us know what you're seeing on this. We really want to collaborate on this because, as you know, it's a fast-moving area. So please do get in touch with CCLI if you want to talk about this further.